Hello viewers, in this video we're gonna discuss about the Delhi High Court ruling on ESOP compensations. So let's begin this video. So before moving further, let's understand how the taxation work on ESOPs. So first of all, understand how many events occur from the grant to exercise and selling of the shares. So at the time of the grant of ESOPs or options to the employee, there is no tax applicable on the same. Second event is vesting. Vesting basically means when the employee has a right to exercise. Now company cannot take back those vested share from the employee. And the third event is when the company open a exercise window, employee can opt to exercise those shares. Now this exercise of share event is a taxable event under the Income Tax Act. Section 17 talks about the same, and they consider whatever be the value accruing to the employees at the time of exercise, they consider as perquisites. And as we all know, perquisite is a part of the salary, so whatever be the taxation rule applicable on a salary, that is also applicable on those perquisites value. And the last event is when you sell those shares in the market. Again, as you usually trade in the stock market, whatever be the shares you buy, you sell, and the differential you have to pay the short term capital gain, long term capital gain, similarly applicable on that. With this discussion, whatever we are discussing in this video, we limit our discussion to the ESOP part. We are not going into the long term and capital short term discussion. So to give you a bit of perspective, so fact of the case was there was an employee whose name is Sanjay Baveja. So this case is between Sanjay Baveja versus the department. The company involved was Flipkart and the Flipkart Limited, Singapore. And this event, how this event started, so in 2022, you have also heard that there was a disinvestment of phone pay, which leads to reduction in the overall value of the Flipkart. And it's quite obvious when you sell your investment, which is quite good, so the overall value of the company get reduced, and by virtue of that, ESOP value also got reduced at that point of time. So far there is no exercise by the employee, and there was no taxation as such. What happened in 2023? The company decided to pay voluntarily. Mark my word, voluntarily. There was no obligation. So voluntary payment because of the value reduction in the ESOP by virtue of this disinvestment. So they gave certain amount, which is USD 43.67 per option as a voluntary payment, and this payment was made by the Singapore entity. The employee, or I would say Mr. Sanjay Baveja, applied under Section 197 to the tax department for the NIT TDS certificate. Section 197 talks about if you consider certain amount is not chargeable to tax or subject to the lower TDS rate, then you can apply this certificate, and department, after due consideration of the facts and the application, they consider such kind of application in the normal course. But in this case, they rejected the application and considered this one-time voluntary payment as a part of the salary, or I would say the perquisites. So they link this one-time voluntary payment to the ESOP. So just to sum up the overall facts of the case, what we have understood, there was a voluntary compensation by the company to the employee by virtue, or I would say the reason was because there was a reduction in the ESOP value. So as a good gesture, or like more prior commercial alignment, this payment was made by the company because there was a reduction. Now income tax department took it in a different way. So they said, because you have received this voluntary compensation by virtue of your ESOP value got reduced, therefore they treated it as a perquisites, or I would say they consider as a part of the salary income, though he was an ex-employee. But if the ESOP were exercised, actually there was a tax implication which had to be paid by the ex-employee. But in this case, there was no exercise of ESOP, and there was no sale of shares by the employee. So far what we understood, under the income tax, these are the only two event which considered to be the taxable event so far the ESOP is concerned. So now the overall question is how to treat this voluntary compensation, whether the income tax department was right to call it as a perquisites, whether there is any implications from the taxation point of view, whether any tax rate applicable in this case. So this was the major issue, how to treat this voluntary compensation under the Income Tax Act, whether the employee is required to pay tax or not. This person moved to the Delhi High Court. While deciding the matter, there were certain a key area or the point of consideration which was as you can see. So taxpayer had not exercised any ESOP. It was a voluntarily, or I would say it was a voluntary payment made by the company to the employee. And again, if you read very specifically the explanation C of section 17.2 subclause 6, they said, as I said earlier also, the tax part will only be contingent on the exercise of option. And as you know, in this case, there was no exercise. And again, as I mentioned earlier, the payment made voluntarily. There was no legal obligation to make such kind of voluntary payment, because these are the risky instrument. Value can be reduced, value can go up. So it's not a company liability to compensate for the reduction, but it was a good gesture, I would say, from the company side to pay for this reduced amount. But the court again observed, you always have to see the substance over the form. Though the genesis or the purpose behind making those voluntary payment was linked with certain, because of there is a reduction in the value of the ESOP, that's why they are making. But as an event, you cannot say it's a perquisites or it's a ESOP exercise or something or other thing. So this was purely a voluntary payment, you can say, without linking to the ESOP. And the second consideration was it was not an obligation on the company part to make a payment. So these were the few facts and the court observation while deciding this matter. High Court decided that the nature of the payment was a capital receipt, not a perquisites. And we also have seen during this discussion that all the circumstances and all the taxation rules work in the favor of showing it as a capital receipt instead of perquisite, because there was no event of exercise or anything which you can say under the Income Tax Act that this amount is a perquisites value. So the Delhi High Court relied on a previous judgment of the Supreme Court, as you can see on the screen, wherein the Supreme Court also decided that the one-time voluntary payment is a capital receipt and not taxable or should not be taxed as a revenue receipt. So this is all about this Delhi High Court ruling on ESOP compensation, or I would say the one-time voluntary payment, which is linked with the ESOP. And thank you so much for watching this video. I hope you like this video. Please share with your friends who are working in this domain so that they can get the benefit of this video.